Well, good afternoon, everybody, and particularly on a day like today, a very warm welcome to everyone to this seminar on making the most of the opening session in clinical negligence mediations. This session is being recorded and will be available on our website after today. We do encourage questions, so if you have any questions or indeed observations, do put them in the chat or the question and answer position, and our chairman Tim Wallace, who's managing the technology today, will make sure we get to know about them and hopefully deal with them. If we can't on today, we'll make sure we contact the author and do our best to respond. So when the NHSLA, as it was then, announced its mediation scheme, its CEO said that the mediation is an excellent forum for dispute resolution, providing injured patients with an opportunity for face-to-face explanations and apologies when things go wrong. So today's seminar is to discuss how everyone participating in clinical negligence mediations can make the best use of an opening session. And to help me describe what an opening session could be or should be, I'm delighted to be joined today by my Trust Mediation colleague, mediator Meera Lachani, a practicing solicitor with experience on all sides of mediation as mediator, claimant solicitor, and defendant solicitor, and our four special guests, Megan Bidder, Director of Safety and Learning at NHS Resolution, and her deputy, Naomi, Assame, and our two solicitor colleagues from Tees Law, their ADR champion, Janine Collier, and from panel firm Browne Jacobson, principal associate and deputy ADR champion there, Jennifer Fagin. So you're all very welcome. Thank you very much, everybody. Meera, can you kick us off? What do we mean by an opening session?
Good afternoon, everyone. Thanks for joining us. Well, I think we can never presume that everyone will know what an opening session is, or often referred to as a plenary session. But essentially, it's when all the parties come together to have a discussion openly with the guidance of a mediator. So it's a joint meeting, different to a joint settlement meeting, but it's under the guise and under the help of a mediator orchestrating that meeting. When can it happen? It can happen at the top of the day. It can happen when everyone is happy to speak together in one room. What we often find in clinical negligence cases is that a claimant may not be ready to speak together openly with everyone around. It can be quite a daunting experience. So a plenary session or an open session can often take place throughout the day if someone decides that they're now ready to speak to somebody together with everyone in the room. The permission of all parties is required for an opening session to happen. So once that's obtained, a mediator can help and assist orchestrate the meeting of everyone together. In my experience, I've seen it work really, really well. I've had claimants say, look, I'm not ready right now, Meera, I'm just not comfortable. But as the days progressed, they felt that they wanted to meet the other side, as it were. And those sessions, in our feedback, have proved very successful, especially when they can allow for a forum where an impact statement can be delivered. So that's not a written statement. It's the defendant or defendants listening to what has happened and the actual human impact of that experience on that particular claimant. And that can be incredibly cathartic for the claimant, but also it affords the defendants an opportunity to perhaps hear something that they've not heard before. The opening session can also set a really good atmosphere for the rest of the day. Negotiations, we find, open up much nicer when ground rules are set and people are reminded to listen to what is being said, not just think about what their response is going to be. And I know we've got people from patient safety here. I've had mediations where patient safety experts have been involved in mediations, And I say that anyone involved, particularly lawyers, advising their clients to think about what it is that they're hearing in those mediations that they've not heard before. What is it that they can offer to their opponents in those opening sessions where everyone is together, where there is a human opposite you? Unfortunately, in litigation, much of what we do is now on the phone or by email, but it's a real opportunity to get your message to land, with a human sitting right opposite you in a very non-adversarial, without prejudice and confidential process.
Well, thank you very much, Meera. I thought it would be quite interesting. I looked at some of the feedback that we get from mediations. Now, it's part of the NHS Resolution Mediation Scheme. We do have to collect feedback if the parties are willing to give it to us and report on it. And I thought I'd just read a couple of comments that have come in recently to us at Trust Mediation. They appreciated the opening session discussion with the defendant before the mediation started, particularly as the Trust explained what changes have been made at the Trust since the father's death. The words expressed by the Trust legal manager at the beginning went a long way with our client. My client was appreciative of the group session at the start of the day when they could ask their questions. The mediation provided my client with a voice, and I know she felt better for speaking at the initial meeting. So that's the kind of feedback we've been getting. We've mentioned, Meera mentioned patient safety. I'm absolutely thrilled that Megan and Naomi have agreed to join us today, and thank you very much for sparing your valuable time. It is, of course, a firm part of the NHS strategy to investigate, advise and learn from mistakes. And one of the 7 pillars of clinical governance in the NHS is patient and public involvement. So Megan and Naomi, you're very welcome. And could you explain to our audience your roles and how you feel participating in mediation can help you achieve your aims and help patients at the same time?
Yeah, absolutely. Thank you so much, Paul, for inviting us along to join you today. It's such an important topic. And we thought what we'd do is that I could say a little bit about NHS Resolution as an organisation and how our focus on learning from claims has developed over the years. And then Naomi, who heads up our safety and learning team, will talk in a little bit more detail about the role that members of the team can play in mediation and some of the feedback that we've had about the impact that that can have both for patients and for staff and organisations. So NHS Resolution, as hopefully many of you will know, is an arm's length body of the Department of Health and Social Care, previously operated under the name of NHS Litigation Authority. And we've evolved over time to have a much greater organisational focus on learning, recognising that resolution is not just about compensation or about the formal part of a claim being brought through the courts, but actually resolution is something much broader than that, which often involves other aspects of understanding what has gone wrong, knowing that learning and action will be taken from that, and actually around the quality of the communication that happens in response to harm. So the function that I need at NHS Resolution, which is the safety and learning team, our remit and our focus within the organisation is to make sure that we are supporting learning from claims. And we do that in a variety of ways. We work on a national footprint. So we have members of the team who will engage directly with trusts to understand their own claims data and translate that into local improvement. And we also work at a national level to identify themes in terms of what we are seeing coming through claims and sharing best practice around patient safety improvements. We also have a significant focus as an organisation around culture. And I think actually that really speaks to what we're here to discuss today around the importance of mediation and the foundation to that being creating a culture where staff feel able and supported to have open and transparent conversations, recognising the importance of apology, the underpinnings of candour, and actually getting the building blocks of culture and communication right, being a foundation to successful mediation and ultimately successful resolution. I did just want to note we're actually due to be publishing our updated annual report and accounts very shortly, and you'll see that come through. But as you are probably aware, as an organisation, we've continued to work to try to keep a higher proportion of our claims out of court, and our last figures indicated that now around 84%, which is a record high of our claims, are able to be responded to through alternative means of resolution, so they don't end up in formal proceedings, which is something that we work really hard to keep improving on. We recognise that experience of harm and experience of litigation itself is something that it is really important for us to work with system partners to keep improving. And one of our strategic priorities, in addition to learning, which I've described, is around fair and timely resolution. So as I've mentioned, keeping things out of formal proceedings wherever we can, looking to support alternative means of resolution. And one of the key aspects that our team are able to support with that is through our attendance at mediation meetings that happen at local level. So I'm going to ask Naomi to reflect a bit, both as the leader of the team, but also as someone who has been our safety and learning representative within some of those mediation conversations.
Thanks, Megan. So, hello everyone, I'm Naomi, as Paul and Megan have just introduced me. I'm a nurse by background. I still work clinically in urgent care. The majority of the safety and learning team are still active in clinical roles. And I think that's an important point to raise when we're talking about this important topic, because the safety and learning team have really helpful clinical context that they can add to that opening session, and also support clinicians that are attending mediation and patients, particularly around the language being used, to sort of understand any nuance that might exist there. As Megan has already stated, resolution in the form of wanting the NHS to learn to drive improvement is a key motivator for patients affected by harm to bring a claim for clinical negligence against the NHS. And there are a few examples that I can draw upon where the safety and learning team have facilitated that learning to drive improvements. The first example that I'd like to draw on is a case of a baby who it wasn't recognised that the baby had developed neonatal jaundice closely after birth, and sadly that baby went on to develop a significant brain injury. The key thing that the family wanted as resolution from their particular experience was for the NHS to learn from what happened to their baby and to what their experience was as a family as a consequence. And actually what we committed to doing was creating a neonatal jaundice case study, which is available on our NHS resolution website, that takes a systems approach to understanding what the contributory factors were to that jaundice being missed by the healthcare professionals involved in the care of that baby and of that family. That has been an incredibly powerful resource. It is now embedded into our education programme. So at the moment, the safety and learning team are delivering a series of in-person sessions to undergraduate healthcare professional courses such as nurses and midwives, and we facilitate a whole session looking at this neonatal jaundice case, thinking about it from a systems perspective, and it just shows sort of the subsequent impacts that can come from a mediation, particularly where learning is the key resolution for a family. Drawing on our clinical experience, like I've already referenced, I think is extremely helpful. I attended a mediation a couple of years ago that concerned a medication error. It was linked to anticoagulation, specifically warfarin. Understandably, the family were concerned that this was an issue that the healthcare system did not recognise as being a patient safety issue. And what I was able to do was to explain that actually at a global level, there is significant attention being given to improving the safety of high-risk medications such as anticoagulants. It is a priority of the World Health Organization. That nationally, reducing medication harm is a patient safety priority. And then also locally, within the trust that the medication error had occurred, there'd been significant improvement activity. Plus, as a safety and learning team, we're already producing a series of insights into medication error claims with a view to driving improvement. And being able to articulate that clearly to a family in a way that they understood was incredibly powerful. They were really reassured that the issue that they thought they were only seeing was actually being addressed at all levels across the world. And that was a really helpful start to that sort of to the whole day, really. It really set the tone in terms of commitment to learning and understanding where the healthcare system is at in terms of making safety improvements. I'll stop at that point, Paul, in case you want to ask me anything else.
Well, one question jumped out at me is, how do you actually get your invitation to the mediation? Because obviously you're not lawyers. Can for example, a claimant solicitor whose client says, you know, one of my items on my shopping list after whatever has happened has gone wrong is learning the lessons. What have they done about it? What can be done about it? And of course, some claimants very much want to be involved in that process. How can you be contacted? Does it have to go via the panel solicitor, or can a claimant solicitor contact you direct? How does it work?
So we have an internal policy, if you like, maybe protocol, where we are actively encouraging our claims handlers within NHS Resolution to identify those claims that are going to mediation, where specifically learning from harm is an important part of the resolution process for the claimant. There are now within Case Hub prompts that pop up to say to the claims handler, is this, if you're going to mediation, is this something that the safety and learning team should be involved in? So we're trying to get more proactive through Case Hub in that space. We're not able to go out and, for want of a better phrase, tout for business with the claimant and panel law firms around what claims, you know, mediations might be coming up that are appropriate for safety and learning to attend, because it's really incumbent on the case manager to make the decision about whether mediation is indicated. But what I would probably say to the audience today is just have that in the back of your brain, that if you see a case where learning is important resolution, maybe just nudge our internal team members to say, have you thought about involving the safety and learning team in this?
Good, understood. So thank you very much, Naomi and Megan, for that, and we'll come back to you later on in this discussion, no doubt. Janine, as an experienced claimant solicitor, what do you and your clients hope to get out of an opening session? Indeed, do you encourage clients to have an opening session at all?
Yeah, thanks, Paul. I think for me, and I always advise my clients of this as well, the opening session is a really good opportunity for us to put the person behind the claim. So it's never lost on me that actually, say for me, everyone around that table is highly unlikely to have ever met the claimant. You know, they are just a name or just a matter number on a piece of paper. No matter how hard that case handler tries to understand what the situation they're in, or you know, tries to empathise with the position. So I always really encourage a claimant, if they can, to participate in the opening session. And really, for me, it's their opportunity to have a voice, It's the one opportunity in a litigation process that they have to actually speak to people who have the ability to try to help them move forwards and to share their story. And if they feel unable to speak and to voice that themselves, then sometimes we'll work with them and encourage them to look at other ways of doing that. So I have in the past, for example, had a client who they prepared a video montage of some photos and some stories, and you know, the case involved twins, and they were talking about how the twins reacted to, you know, and worked together. And that was a way that they were able to bring that story, even though on the day they weren't confident that they were going to be able to speak without breaking down. And I think that was a really, really powerful message that they were able to share.
Oh, thank you, Janine. Jennifer, from your point of view as a panel solicitor, what's your experience of opening sessions? Do you encourage the claimants to have them, and what do you seek to get out of it from your client's point of view?
Yeah, I find opening sessions of mediations really beneficial, and it can really set the tone and break down barriers. So for us and our clients and the people from the hospital, sometimes it's the very first time that we've actually met the claimant, in terms of the representations, the first time we've met the claimant or the legal team in person. And depending on the issues in dispute, it's a real chance to provide an explanation as to what or why something's happened, if appropriate to give an apology or acknowledge that something's gone wrong or that there were failings, and also a real opportunity to discuss learning changes or measures in an organisation that have happened since the index events. From a defendant's perspective, we appreciate that some of these claimants may have waited years for this moment, and we appreciate that they may feel it may be quite daunting, or they may feel anxious for the claimant. So the opening session is really important because often or sometimes the claimant may have some mistrust, and it's an opportunity for us to build that trust back by listening actively and establishing a good rapport. The opening sessions, I found them really beneficial to actually acknowledge face to face with the claimant what they've been through and how it's made them feel, and a chance to say where it's appropriate, like to say sorry face to face, because the opening sessions I found can be a real springboard for collaborative discussions. So one thing that we feel it's really important with opening sessions is to remain open-minded and listen actively. And it's not a place to be adversarial or score pointing or anything like that. And from our defendant's perspective, a claimant who leaves that opening session feeling respected and genuinely listened to, and that we genuinely want to work with them collaboratively, is more amenable to and prepared to possibly negotiate throughout the day, whereas a claimant who feels unheard or dismissed, or regardless of what figures or proposals we might make, may actually be more inclined to become entrenched. So the opening session is really important, and it's creating the right atmosphere. And from a defendant's perspective, we appreciate that all claimants are so different in how they react. Some may be angry or emotional or frustrated, or some of them might just want to tell us more about themselves or their loved one that's had harm. I've had examples or mediations where the family wanted to play a video of the child opening their Christmas presents, and it's a child who had unfortunately passed away, but the family really wanted us to see how the child had a sense of humour and the character and the essence that made the child him, and to put it into context. And that was so powerful, and it really brought the human element to the forefront, and for us to understand and hear what was important to that family, so that we could. It was just a really good opportunity. And if we hadn't have had that opening session, we may never have had that opportunity of the family to show us those videos. So from the defendant's perspective, it's incredibly important. And we really, where we can, we encourage claimants, but I've had cases where claimants haven't felt they wanted to do an opening session, and it may be that the legal representations have met instead in the opening session, but we may have done a closing session where the claimant entered when they felt they wanted to. From a defendant's perspective, we found that actually opening sessions can also be important where in those cases where liability is in dispute as well. So to hear each side directly, where there may have been previous misunderstanding or some clarifications needed about the factual or the legal issues in dispute, and also for parties to frame the dispute. So an opening session can be important for clarifying the key points from the parties. And actually a well-handled opening session can actually move the parties away from an adversarial approach to more of a collaborative, as I mentioned before, and a practical approach to work together. So yeah, we really do encourage the mediation and the opening sessions of mediations.
And Jennifer, you would agree, wouldn't you, that it's a pretty good forum for you if there are odds and sods of ends that you want to be brought up to date on or tied up with the claimant, to see if the claimant side can just give you that update. It could be you know, the result of a recent operation, or a change of job, or a change of house, or something that brings everything up to date, because my experience is that many of these cases have taken years, and a lot of the information you have is historic because it's in the original pleadings or it's in the original reports, but actually it helps to update, and that's usually pretty non-contentious. Janine, if you got a request for information from a defendant solicitor and say, well, could you give us this information, you know, as part of the opening session, what would your response be?
Oh, absolutely. It's information that we would share. I think also, though, Paul, one of the things that is very helpful in terms of the mediation as a whole, but also then the opening session, is to make sure you've even prepared in advance of that. Because, of course, when we're thinking about what the claimants want, what the families want, we need to make sure we have the right people in the room as well with that. So I would often have conversations with my opposite number in advance, so that before we even get into the room, we're very clear, for example, around what the claimant is looking for in that scenario. And so hopefully at that stage, we would already have shared updated information that would be helpful to the defendant as well when they came into the room. But if that hadn't already happened, absolutely, it's something that we would be willing to discuss and encourage the claimant to share, because ultimately we're all there because we want to get to a resolution. So anything that we can both do to help each other get there has to be a win-win.
One thing I would I just add to that, Paul, just to what Janine is saying, just from a practical point of view. One of the things that I find quite helpful is when you have a pre-mediation call with the mediator, the mediator can ask you, or having read the papers, might say, have you thought about this? Just as an opener, it's up to you what you want to do with that information. But equally, it's fine for any solicitor or lawyer or representative to say, look, I'm thinking I might bring this person along. I think they'll be good in private session or even an open session. I think that's fine to do too. If you're not sure, that's fine. And it's okay to ask the mediator, this is what I'm thinking of doing, if there's value in doing it. So don't be afraid, I would say, in being open and having that discussion with the mediator in advance, because I've seen it where there's been an opening session, but actually the claimant wanted to continue the discussion with patient safety in private. So the opening session just gave that wonderful opportunity to say, okay, I think they really want to listen to what I've got to say. And this has been going on for about 4 years. And actually what we were able to do is then have that discussion in private with patient safety, because that's what she really, really cared about. So there are ways in which you can adopt and, you know, make the process quite flexible to help the patient and the claimant, but also from a patient learning perspective to see what they can do to prevent harm going forward. So the pre-mediation call can be key for that.
And I think certainly when I'm doing training sessions for either claimant solicitors or defendant solicitors, quite often one of the difficult concepts to grasp is what is the role of an independent neutral? Why are you there? And one of our roles is as choreographer of all this, because if the parties can be open with us as to what their aims and aspirations and wishes are, and convey that to us in the pre-mediation call, we are already a long way in which to plan how we can meet the requirements to achieve resolution or closure or whatever it is. So that I would emphasise to the parties the importance of that pre-mediation call, and of course of communicating with each other as well as the mediator. I was going to ask you, Jennifer, about this phrase, getting the right people there, because as mediator, I see that hugely important to a lot of claimants.
Yeah.
I mean, we're all lawyers, except obviously Megan and Naomi, and it's very easy for lawyers to think it's their case and to act as if it's their case. But I know when I go into the individual rooms, and this is the huge benefit and bonus, if you like, of being a mediator, we can go into each room. I see the importance that the lay client, not the claimant solicitor, but the lay client relates to when I say, oh, in the other room, there's someone from the trust. Or sometimes I will be asked by the lay claimant, is there anyone from the trust? It means a lot for their mere presence to be there, if that's possible. And in the online world, it doesn't mean they have to have the day out. We as mediators can again choreograph the timings and so on. But do you find difficulty persuading your clients of the importance of their presence?
This is a really good point. I mean, I completely agree. Having the right people there is essential, and it can really, really make a difference. And on some of the cases that I've dealt with, I've actually said to the claimant solicitor, you know, is there anyone in particular that your client would like there? Sometimes some of the claimants do have someone in their mind, and it may be a divisional lead, or it may be, I've had an example where a patient wanted the medical director present, and with that we then went to we advised NHS Resolution, we advised the trust, and explained to them why having the medical director there would be beneficial. And I think it's really key to have the right individuals there. And we can also obtain, ask for various people from patient safety groups within trust, divisional leads. On one case that Naomi and I worked on, Naomi attended from NHS Resolution, and I think we had the medical director present at that one, possibly a consultant, possibly as well. It was a very, very sensitive case, and having those people there was imperative to explain what had gone wrong at the time, back at the index events, and the learning that had been done since. And I think when we go to our clients, it's explaining to them, you know, we do want the medical director's presence would be imperative on this case, and explaining why. And usually when we do that, we can, depending on the circumstances in the case, it does make a difference getting there. Naomi, do you remember the case that we worked on when it did make the difference having those key people there, and the trust understood the reasons why, because it was important for the claimant to speak to them directly on a one-to-one basis.
And at the extreme end, I can tell an anecdote without revealing any confidences, is that I once was mediating a clinical negligence case, and there was someone from the trust there, the clinical director, and he said to me, I am desperate to meet the claimant. Is there any way I can meet the claimant? And I said, well, yes, of course. You know, I'll go and ask the claimant if you know, may I ask why? You know, he said, I'd quite like to meet her on my own. He said, I saved her life. I was the surgeon in the operating theatre when it all went wrong, and I was called in, and I saved her life. She may not know it was me, but I would very much like to meet her. So I went to see the claimant. I explained what I'd found out, and she was very reticent indeed about doing that. You know, it came as a bit of a shock. And I said, look, I'll go with you, but there won't be any lawyers. I'm a lawyer, but I'm a mediator. You know, I'll hold your hand. I'm sure it'll be all right. So she agreed, and I took her, and in this room was the chief executive on his own, and they just fell into each other's arms. They both broke into tears, and that no words were spoken. They didn't need to be. There was no apology, there's no need for any of that, but it was closure for both sides in the end.
It's bringing that
And-
human
and-
element back into it, isn't it? It's bringing the human
Absolutely.
element, and actually that clinicians who've entered the healthcare, you know, to help people not to harm, you know, they can be genuinely really upset, some of the clinicians, as to what's happened, and that it's in that case, Paul, it sounds like it actually, like you said, closure for both. It had affected both the clinicians and the claimant. And
I was going
Yeah,
to.
Megan,
may
can
I
I
interrupt a second, Paul, just
Yeah.
to let you know, you've talked about choreography and Meera was talking about preparation. We have an observation from mediator Elizabeth Francis in the chat, and Janine also has her hand up to ask a question, I think. But would you like me to read Elizabeth's comment?
Yeah, sure. Go ahead, Tim.
So Elizabeth Francis says this: as a mediator, I will always start the conversation about a plenary session at the start or otherwise in the pre-mediation chat. This really helps the parties to start to think about this as an option and enables the claimant to start thinking about whether they may be prepared to do this at some stage and what they'd like to say. And I certainly endorse that from my own practice. So that's to you know, it's reinforcement of what both of you were saying. And as I mentioned, I think also Janine may have an observation or a question also.
Yeah, I mean,
Janine, over to you.
I was just going to pick up and really emphasize the right people in the room point. And also, I actually think the right mode as well. One of the most powerful mediations that I had was where the clinicians involved in treating, not the medical director, not the sort of person who has done the review, but actually the clinicians involved in treating and the claimant were in the room together. And seeing them work through that and seeing them at the end actually hug each other before they left, because it had been really traumatic for everyone involved. So, you know, that again was something that it was important to have the clinician there who had treated, but it was also important to be in person. And remote definitely has, I think, you know, there are a number of benefits to it in terms of timetabling and clinician time and the like as well. But I do think that sometimes in person is what is needed to really meet both sides' outcomes. And that's something that, again, I would always think about in advance to position the mediation in the best possible way.
on one of the cases that I worked on, we said to the claimant, you know,
Yep.
where would you like the mediation to take place? Would you like it to be in? Are you happy for it to be in our offices, or would you want it in your claimant's, your solicitor's offices or your barristers? And the claimant actually picked the venue and actually picked it to be at Browne Jacobson's offices. And we sort of just having that, taking into account their views and asking was key really in making that opening session. We also allowed the claimant, we said to him, you know, do you want to go into the room beforehand? We said to the mediator, show him around the room so he feels comfortable in that room where the opening session would take place. And it was those little extras that just helped the opening session for that claimant to feel comfortable.
Yeah. So the other big extrajudicial remedy that can be dealt with from the shopping list of claimants at the opening session is, of course, apologies. And when they're done well, they're done very well and have the desired effect and definitely create the right atmosphere. When they're done badly, it can be disastrous, not only for the parties involved, but also as to the prospects of settling the case. So I just wondered, I'm, as mediator, quite often told by a defendant lawyer, we can't give an apology because we're denying liability. And I just wondered, Megan, if you could explain or help us as mediators to explain to parties why that's not the right way to respond.
Yeah, it's such an important point, Paul, and we see it often. And you will hear us say very clearly as an organisation, and indeed you'll hear Helen Vernon, our Chief Executive, in various forums say that apology is always the right thing to do, and that does not, you know, sort of prejudge the outcome of any future process. It is the right thing to do on a human to human level to acknowledge, that someone has experienced harm. And we recognise that message doesn't necessarily translate easily to, to clinical settings and cultures where people are, I suppose, increasingly feeling vulnerable. I guess that's what we see, is an increasing sense of staff feeling like they almost need to cover their back in advance of something getting into proceedings further down the line. And I think, we as an organisation are keen to keep developing and seeking ways to share that message, that really the first order thing and that human to human level is to apologise when things have not gone as they could.
The most common area of confusion, I think, in the mediation context is where there's an admission of breach, but a denial of liability because causation isn't admitted. And of course, liability contains both elements. And I've been told on numerous occasions, we can't give an apology because we're denying causation. But by admitting breach, of course, you're making it clear that things didn't go right. They might not have altered the outcome, subject to the experts' views, but that is a real problem area of conception to a lawyer, I think, that needs to be overcome in the healthcare context. Also, timing is important. We mentioned timing quite a lot so far today. I just wondered, Janine, have you experienced problems getting last-minute apologies the night before a mediation, or a pretty anodyne apology doing more harm than good?
I would say actually, Paul, I've experienced the two extremes. I've had a couple of mediations where the defence has arrived and has basically almost treated it like, I don't even want to say a JSM, almost like a trial, as in they've opened and they've literally just rehearsed the reasons why you're wrong on every single matter, and that immediately puts the wall up, and it doesn't help a claimant move forwards, and it sets the tone for the mediation as a bit of a car crash. Otherwise, I've had really good experiences where people have absolutely arrived and have given that apology that has just been discussed, which is not an admission of liability, but actually what it helps the claimant feel is that what has happened to them has been recognised and heard, regardless of fault. And that in itself is meaningful to them. So yeah, I sort of actually haven't had anything really in the middle, Paul.
I had an example which is quite telling, actually. It was an NHS case, but not a trust case. It was a GP case. And the GP was not at the mediation. Indeed, he'd retired and was living in a foreign country. But at the start of the mediation, the defendants team asked if we could have a plenary session, and the claimant relatives, because it was a deceased case, declined. And as mediator, I have no power to force anybody to do anything. So we did the mediation in the conventional shuttling way. It ended up being resolved. But before we got to the shuttling, the defendant team gave me a letter that the GP had written and said, we were going to read this in the opening session, but there isn't going to be one. Will you take it into the other room? So I took the letter. It was from the GP, who said, I've been your family solicitor all my life. As you know, I've now retired. I'm living abroad. I would have been here, but I can't get back. I'll be thinking of you. I appreciate that you have concerns. I'm really sorry that it's reached this stage, but I wish you all the best for the future. Now, that is a form of apology. The family received it tremendously well. So well, in fact, that once we'd settled the case, they asked if they could meet the defendant's lawyers, and there was only a barrister and a solicitor there. And they went in and they thanked the barrister and solicitor, and they ended up talking man to man, woman to woman, for half an hour about all sorts of things. But it was just the right thing, set the right atmosphere, and almost certainly triggered the eventual settlement. So there's all sorts of ways of doing it. The worst case I've had was the letter arriving the night before, signed with an indecipherable certificate without stating anything other than Chief Executive underneath, and the wording being totally anodyne. And the recipient walked out of the mediation within 5 minutes, having protested about the receipt of that document. So that's the other extreme. Creating the right atmosphere, getting the timing right. I'm old enough to remember a pop song of the 1980s. I think it was Banana Rama who did it, but I'm not going to sing it to you. But the lyrics sum up, I think, what we've discussed so far today. They go something like this: it ain't what you do, it's the way that you do it. It ain't what you do, it's the time that you do it. It ain't what you do, it's the place that you do it. And that's what gets results. So that's how I actually, I put it in my training sessions, and those of you who've been to Foyle and to NHS resolution regional meetings will probably have heard it. But I think it's just worth remembering some of the lessons that we've talked about today. The other thing I wanted to talk about before the end was language. Language, in my view, is tremendously important, and it's the way, obviously, we all work. I just wondered, either Naomi or Megan, can you fill us in with how best we can train lawyers and mediation advocates to use the right language in mediations? I'll give you 2 examples. Baby instead of fetus, and Fred instead of deceased, and things like that. Because my experience is that it's better to humanize it, and that's one of the lessons we've been talking about today. I just wondered what work had been done on that, and what do you think of that as a point?
I think it's a very important point, Paul. If I reflect on my own nursing practice, very early on in my nursing practice, I can remember caring for a woman who had miscarried and referring to her baby as products of conception. And I remember her very vividly saying to me, "Why do you keep saying this?" And I wrote a reflection on that as a nurse afterwards, saying, because I think it's a way that I'm distancing myself from the situation that is actually very difficult on a human perspective. So I think it's recognising that we are all humans, and that we can relate to that, and we're allowed to relate to that, and our language should allow us to relate to that as well. We should be very compassionate, we should be very bespoke in the language that we're using. And I think also being really careful not to inadvertently invalidate what the family member or the person that's been affected by the harm is telling us about their experience. I think that's something that we can very easily trip into, particularly in sort of the more adversarial spaces. And I think that's something that we have to be really, really cautious about. And certainly through quite a lot of our resources, we talk about, you know, the appropriate use of language that sort of takes into consideration sensitively and compassionately the patient perspective and the patient voice, but also in engaging with family groups, patient groups, to understand from them what is the language that they feel would be best to be used in these situations. I think that resource is underutilised, and we could probably sort of, as a medical legal healthcare system, could be calling on quite a lot more.
Yeah, I don't have much to add in addition to what Naomi has said, but absolutely I agree. It's you know, about making our communications human-centered, and that can be a real challenge when we're talking about legal processes. And for example, when you're talking about the whether it's the Balen test or the sort of the various thresholds that have to be met as part of a sort of proof of evidence in a court proceedings, that can feel very process heavy. And I think we would always want to work particularly within our function within NHS resolution, to support the system to think about the impact that language has. And as Naomi mentioned, we do that through a lot of our products. So one of those is our saying sorry guidance, where we specifically aim to help clinicians think about the language that they use as part of that apology. I did just briefly want to reference, because it's part of the work of my directorate, that we are as an organisation increasingly trying to work directly with families to think about how they would like to be communicated with. And we're doing that particularly as part of our early notification scheme, which many of you will be familiar with. But over the last 2 years, we've established a new family liaison team within NHSR who are able to more directly communicate with, signpost and support families through the early notification process. So I think it is something that as an organisation we're increasingly, investing in and increasingly mindful of. But it is, it's an area that I'm sure across the board we can keep improving in.
And it's right, isn't it, Megan, that you've also from time to time invested in actual claimants that you've come across in mediations, or maybe it's Naomi's experience, where a claimant has self-evidently got a story to tell that you feel would be extremely useful heard in a wider audience for lessons learned, because chalk and talk is okay, but real people giving experiences the way. Have you come across people? I mean, I've had as mediator people from your team there who've gone up to claimants and asked them if they'd like to be involved in a campaign or talk to the local trust or indeed nationally. But have you experienced that? And how do you go about recruiting, if you like, volunteer claimants and volunteer families?
So we have done that in the past. We have to be careful. There's some sort of considerations that we have to give around when it is appropriate to recruit, if you want to use that phrase, somebody to a campaign. But what we tend to do is, somebody very clearly articulates or verbalizes that they want to be actively involved in a webinar. And it might not be a webinar something that NHS resolution necessarily facilitates, but they give us their permission to introduce them to organisers of webinars where their experience would be very much welcomed and provide very important context to the messaging being given within a webinar. We've done that quite a few times, and that's been incredibly powerful and led on to other things where people have sat then as advisory members on clinical guidance groups, for example, representing the patient voice. So it's sort of that sort of snowball effect that we can have where we identify somebody that's really keen to be actively involved in the improvements that come as a consequence of mediation. And I think sometimes we can underestimate or undervalue the role and the impact that the patient voice can have in terms of driving improvements that are actually effective and successful.
And just by way of extension of what Naomi said and what Megan said, I think healthcare is quite unique in that the doctor or the nurse, etc., may have an ongoing relationship with the claimant or the patient. It's not always there's a claim and that clinician is no longer involved. I've seen it where an apology or an open session has actually been one where the claimant has said, I want you to stay as my GP. And it was a really bizarre situation because something had gone terribly wrong. But at the same time, this person had had this GP, they'd been a family GP for such a long period of time. They wanted to maintain that relationship. So whether we're talking about language that's being used or whether we're talking about harm, etc., sometimes preserving that relationship is just as important for both sides often. And I think an open session and all this clarity that we're talking about today can be a really good forum to explore and sometimes where it's appropriate to continue that ongoing relationship that healthcare professional may continue to have beyond the litigation as well. So I think that's always something to consider as well.
Yes, thank you very much, Meera. Well, can I draw this webinar to an end? I don't think, Tim, there are any questions. So we've obviously browbeaten the sweltering audience today. But can I thank our panel very much for their time and their contributions today. Hopefully there's been quite a few lessons learnt and interesting points made that will improve the quality not only of the mediations and the representation of mediations, but also dealing with lessons learned and so on, the degree to which improvements in healthcare can derive from continued collaboration between the parties that we've tried to illustrate as part of the mediation process today. So thank you very much, everybody, and good afternoon.
Thanks, Paul.
Thank you. Bye.
Thank you, Paul.
Thank you very much.
Okay, there were a couple of people hanging on. Maybe they'd gone for a sandwich.